Welcome to Criminal Law class. This class is on loss of control, an examination of the partial defence that reduces murder to voluntary manslaughter when defendants lose self-control under specific circumstances. My name is Nasir Hafizi. I am a solicitor and a senior lecturer. So the learning objectives for this class is basically four things. One is to give you some historical development, explore the evolution from provocation to loss of control defense, partial defense. Secondly, to look at the partial defense nature, explain why loss of control reduces murder to voluntary manslaughter. Thirdly, the defense components, understand the three essential elements required for the successful defense of loss of control. And four, to look at the evidential issues and grasp the burden of proof and judicial filtering mechanisms in the issue of the partial defence of loss of control. As always in these criminal law classes, there is a set of true and false questions. It is just simply to test your knowledge after you've watched the video, but please look at the questions now. Question one is true or false, the defence of provocation still applies alongside loss of control. Question two, true or false, loss of control is a partial defence that, if successful, reduces murder to voluntary manslaughter. Question three, true or false, under section 54.2 of the Coroners and Justice Act 2009, loss of control must be sudden. Question four, true or false, section 54.4 excludes cases where the killing was motivated by a considered desire for revenge. Question 5, true or false, a qualifying trigger may be raised on fear of serious violence against the defendant or another identified person. Question 6, true or false, sexual infidelity can never be considered by the jury in assessing loss of control. Question 7, true or false, according to R versus Clinton, sexual infidelity may be taken into account if it forms part of the wider context alongside other triggers. Question 8, true or false, words or acts amounting to circumstances of an extremely grave character causing a justifiable sense of being seriously wronged can amount to an anger trigger. Question 9, true or false, a defendant who deliberately incites violence in order to provide an excuse for killing can rely on loss of control. And question 10, true or false, the third requirement under section 54.1c asks whether a person of the same sex and age with a normal degree of tolerance and self-restraint might have reacted in a similar way. Again, in these criminal law classes there are three single best answer questions. Two of them are relatively simple. It's just to test your knowledge to see whether you are understanding the concept. The defendant lives with her violent partner, the victim, who has a history of assaulting her. One evening, after hours of threats, the victim grabs a kitchen knife and tells the defendant he will kill her while she sleeps. Later that night, when the victim puts the knife down on the table to answer a phone call, the defendant seizes the opportunity and stabs the victim fatally. At trial, the defendant claims she lost control because she feared serious violence from the victim. Which is the correct legal position? Is it A, D cannot rely on loss of control because the killing was not immediate? Is it B, the defendant may rely on loss of control because fear of serious violence is a recognised qualifying trigger? Is it C, D cannot rely on loss of control because her reaction was premeditated? Is it D can rely on loss of control only if she also proves diminished responsibility? Or is the answer E, D cannot rely on loss of control because she should have left the relationship instead? And then second single best answer question is, the victim repeatedly taunts the defendant at work, calling him humiliating names in front of colleagues. One day the victim shows defendant explicit photographs of his wife having an affair and says, "Your pathetic husband." Everyone laughs at you. Defendant, humiliated and enraged, grabs a hammer from his toolbox and strikes the victim several times, killing him. Which is the correct legal position? A, defendant cannot rely on loss of control because words alone can never be a trigger. Is it B, D may rely on loss of control if the jury finds the victim's conduct was of an extremely grave character, causing a justifiable sense of being seriously wronged? Is it C, defendant cannot rely on loss of control because he acted in anger, not fear? Or is it D, D, may rely on loss of control only if he proves provocation still applies. Or is the answer E, D, cannot rely on loss of control because humiliation is never sufficient. And then single best answer question 3, a little bit more detailed in the fact scenario. Defendant has been married to the victim for 10 years. Their relationship has been strained, partly because defendant suffers from depression and has previously attempted suicide. One evening, after returning home from work, the defendant confronts the victim about rumours of her affair. The confrontation escalates. The victim admits she has been seeing another man for several months. She mocks the defendant, saying, "You're pathetic. He's everything you're not." The victim ridicules the defendant's depression and past suicide attempt, adding, "Why don't you just do it properly this time and save us all the trouble?" In front of their children, the victim laughs and tells them Daddy is a worthless joke. Overwhelmed, humiliated and enraged, the defendant loses control. He grabs a heavy lamp and fatally strikes the victim. At trial, the defendant raises the defence of loss of control. Now, which is the correct legal position? A, sexual infidelity alone is always sufficient to constitute a qualifying trigger. B, sexual infidelity can never be considered in loss of control cases. Is it C, sexual infidelity may be considered if it forms part of a wider context alongside other qualifying triggers such as grave insults and taunts? Is the answer D, D cannot rely on self-control because depression is irrelevant to the defence? Or is the answer E, D cannot rely on loss of control because he acted from a considered desire for revenge? So let's look at loss of control in some detail now before returning to those true and false questions and those 3 single best answer questions. So what is loss of control? Loss of control is the second partial defence that we've looked at. We looked at previously diminished responsibility in a previous class, which if successful reduces murder to voluntary manslaughter. It only applies after the prosecution proves the defendant killed with intention to kill or cause grievous bodily harm. Now, the rationale recognises that everyone has a breaking point. Circumstances may push people so far they lose self-control, making them less morally culpable than deliberate murderers. There are common scenarios, and these are just, there may be others as well. Racial taunts, physical ridicule, family insults, or infidelity discovery. So racial taunts, defendant reacting to discriminatory abuse and harassment. Physical ridicule, responses to mockery of disabilities or physical peculiarities. Family insults, violent reactions to attacks on family members or friends. And infidelity discovery, finding partners engaged in sexual relationships with others. The objective element. Now, simply losing self-control isn't sufficient. The law prevents volatile individuals from exploiting defence for trivial provocations. What if someone takes offence at their girlfriend smiling at another passenger on the train? Should they rely on self-control as a partial defence if they beat their girlfriend to death? The law says no, introducing an objective element to prevent abuse of the defence. And we're going to look at the elements in more detail. The historical background is connected to this other concept called provocation. Now, Section 3 of the Homicide Act 1957 originally codified the common law defence of provocation, and this consisted of basically 2 tests, subjective and objective. Subjective test was the defendant provoked by things said or done to suddenly and temporarily lose self-control. Or objective test, would the provocation have made a reasonable person lose self-control and acted as the defendant did? So you had 2 basic tests and they conflicted with each other. So the problem with provocation was the government argued that provocation was too generous in cases where defendant killed in anger. The objective test was proved particularly complex and uncertain. Key controversy centred on defining the reasonable person. Could defendant characteristics be considered? Cases like DPP versus Kaplan and DP versus Smith-Morgan created conflicting precedents. Key cases in provocation development, so you had DPP versus Kaplan, that was in 1978. Established reasonable person is the same sex and age as a defendant. Then you had a case of R versus Smith, 1998. Controversial decision allowing jury to consider any of the defendant's characteristics. And then you had the Attorney General versus for Jersey versus Holly, limited characteristics to gravity assessment only, not self-control standards. So because of the past conflicting tests, a new defence of loss of control was developed from that history. Due to complexity and difficulty in jury application, the government abolished provocation and replaced it with loss of control under section 54 and 55 of the Criminal Justice and Coronation Act 2009. Section 56 both abolishes the common law defence of provocation and repeals section 3 of the Homicide Act 1957. You can see the how the law was enacted in 2009, and I've actually written it all down there for you to look at, but I do advise you to look at the section 54 directly. So where a person D kills or is party to the killing of another, D is not to be convicted of murder if, and then you can see A, defendant acts and omissions in doing or being a party to the killing resulted from the defendant's loss of control. So there you go, the loss of control. B, the loss of control had a qualifying trigger. And C, a person of defendant's sex and age with a normal degree of tolerance and self-restraint and in circumstances of the defendant might have reacted in the same or in a similar way to defendant. And when it comes to those qualifying triggers, you'll see that in the next slide, what those two qualifying triggers are. But let's look at part 2. For the purposes of subsection 1A, it does not matter whether or not the loss of control was sudden, so it doesn't have to be sudden. Look at 3. In subsection 1C, the reference to the circumstances of defendant is a reference to all of the defendant's circumstances other than those whose only relevance to defence conduct is that they bear on the defendant's general capacity for tolerance and self-restraint. I'm going to explain that part in the slides in the future. Then you look at 4, subsection 1 does not apply if in doing so or being a party to the killing, the defendant acted in a considered desire for revenge. So revenge is excluded from loss of control. Look at subsection 5. On a charge of murder, if sufficient evidence is adduced to raise an issue with respect to the defence under subsection 1, the jury must assume that the defence is satisfied unless the prosecution proves beyond reasonable doubt that it is not. So the prosecution needs to disprove it beyond reasonable doubt. Look at subsection 6. For the purposes of subsection 5, sufficient evidence is adduced to raise an issue with respect to the defence if evidence is adduced on which, in the opinion of the trial judge, the jury properly directed could reasonably conclude that defence might apply. And I'm going to look at what that means in a future slide. A person, subsection 7 is a person who, but for this section, would be liable to be convicted of murder is liable instead to be convicted of manslaughter. So that's if it's successful. The issue of loss of control is a partial defence. It's reduced from murder to manslaughter. And then the final one is in this section is subsection 8. The fact that one party to a killing is by virtue of this section not liable to be convicted of murder does not affect the question whether the killing amounted to murder in the case of any other party to it. So basically, if there's 2 more people who are accused of murder and they're both considering loss of control, then you need to look at each individual's case. Now this slide, section 55, refers to those qualifying triggers. So there needs to be a qualifying trigger to trigger the loss of control. Subsection 1 refers to section 54, subsection 2. Now here are 2 qualifying triggers, and I'll pay real careful attention to this. A loss of control has had a qualifying trigger if subsection 3, 4 and 5 applies. So 3 is the subsection applies if defendant's loss of self-control is attributable to the defendant's fear of serious violence from the victim against the defendant or another identified person. Subsection 4, this is another trigger. So you've got subsection 3 is one trigger, and then this is the next trigger. This subsection applies if defendant's loss of control was attributed to a thing or things done or said or both which constitute circumstances of an extremely grave character and cause the defendant to have a justifiable sense of being seriously wrong. So there are two qualifying triggers. One is in subsection 3 and the second one is in subsection 4. And I'm going to explain each of those qualifying triggers in the next couple of slides. Now this subsection 5 refers to, in this subsection applies if the loss of self-control was attributable to a combination of the matters mentioned. Subsection 6, in determining whether the loss of control had a qualifying trigger. A look at A, defendant's fear of serious violence is to be disregarded to the extent that it was caused by a thing which the defendant incited to be done or said for the purposes of providing an excuse to use violence. So basically, if the person incites another person to be violent and then the person then attacks that person, that's to be should be disregarded. And then look at B. In a sense of being seriously wronged by a thing done or said, it is not justifiable if the incited thing to be done or said for the purposes of providing an excuse to be violent. And in subsection C, this is again excluded. The fact that a thing done or said constitutes sexual infidelity is to be disregarded. So you've got examples of what is to be disregarded, what a defendant cannot rely on. Now let's look at this in more detail. Definition under section 54 of the 2009 Act. A person is not to be convicted of murder if A, they have a loss of control. Defence Act results in defence loss of control, self-control. And then B, the second element is there needs to be a qualifying trigger, and there are two of them. The loss of self-control had a qualifying trigger. And then there's this third element, which is there must be some sort of similar reaction. A person of defendant's sex and age might have reacted similarly. And I'm gonna look at all three of these elements. So the three key elements for loss of control, and which fundamentally changes from provocation. So one is there's no sudden requirement. Loss of control need not be sudden. It introduces this issue of qualifying triggers must be present, and they're commonly referred to as fear or anger based, and it creates a higher threshold, more restrictive than previous provocation defence, bringing in this idea of age and sex. And just before we look at the elements, let me just those three elements that make up loss of control. The evidential burden. So unlike diminished responsibility, loss of control follows conventional criminal burden of proof. So section 54(5) places only an evidential burden on the defendant. Once the accused produces some evidence, and that might be in the police station giving the account, or it might be in the box when the defendant gives an account of what happened, raising the defence, the burden reverts to the prosecution to disprove loss of control beyond reasonable doubt. So let's look at each of these three elements. The first element, element 1, defendant must lose control. Defendant must actually lose self-control. This is a question of fact for the jury. The assessment is subjective. This particular defendant must have lost self-control, not just that a reasonable person would have done so. It's subjective. In Art versus Jewell, loss of control was defined as a loss of the ability to act in accordance with considered judgment or a loss of normal powers of reasoning. An example of Steve and Jackie here. Steve's wife Jackie constantly criticizes him and throws saucepans. Steve is exceptionally calm but decides he can no longer tolerate her behavior. Not wanting to pay divorce settlement, he plans to kill her the next time she insults him. 2 days later, he strangles Jackie. The result, Steve cannot rely on self-control because he planned Jackie's death rather than actually losing control. No need to be sudden. That's a big difference. Section 54(2) provides that the reaction need not be sudden. This accommodates domestic violence victims and survivors whose reaction build up over time. The famous case of R versus Ahluwalia case exemplifies this. Initially unsuccessful because of loss of control had to be sudden, but the law changed to recognise delayed reactions to cumulative abuse over the years. Considered desire for revenge, you'll notice in section 54.4 excludes cases where the defendant acted in a considered desire for revenge. This prevents planned attacks from qualifying as a loss of control. The government specifically aimed to exclude honour killings where victims are killed for perceived family dishonour. Factors indicating revenge include arming oneself, evidence of planning, or significant delays between the provocation and the killing. Example of Jackie's domestic violence cases. Look at the first situation. Immediate response. Jackie kills husband after he threatens to slap her, following years of abuse. So in this case, the defence is likely to succeed. The final comment was a straw that broke the camel's back. Look at the second situation. Planned attack. Jackie leaves the house, plans killing for 3 hours, returns and executes the plan of killing the husband. Defence fails. Evidence of revenge, not loss of control. And then look at the final example. Fresh provocation. Husband slaps Jackie and leaves, and upon his return causing Jackie to snap. Defence may succeed due to the fresh loss of control. Importantly, when it comes to multiple defendants, under section 54.8, one party successful doesn't affect others' liability. If two defendants attack and kill the victim, one may still face murder charges even if the other successfully pleads loss of control. Each defendant's case is assessed individually based on their circumstances and mental state at the time of the killing. Now we look at element 2 of loss of control. There are the qualifying trigger requirement. The government felt provocation was too generous to those killing in anger and poorly tailored to killing in response to fear. Parliament under Secretary Maria Eagle stated the new defence needed a higher bar with specified qualifying triggers. The intention was to make the defence available in fewer cases than previous law, requiring either fear or anger triggers or a combination of both. And it's a bit like a switch. So section 55 refers to two qualifying triggers. Fear trigger, loss of control attributable to fear or of serious violence from the victim against the defendant or another identified person. That could be a child of the family. Or the qualifying trigger could be an anger trigger, things done or said constituting an extremely grave circumstances causing a justifiable sense of being seriously wrong. Or it could be a combination of both, loss of control attributable to combination of fear and anger triggers. Exclusion is from as a trigger would be incitement. So section 55.6a and b prevent defendants from relying on triggers they deliberately incited to provide an excuse for the violence. So the example here is Steve insults Tony and his family to start a fight. When Tony attacks with a baseball bat, Steve stabs him fatally. Steve cannot rely on fear trigger as he incited the violence to provide an excuse for his response. Look at the fear trigger in detail. Section 55.3 applies where the loss of control was attributable to the defendant's fear of serious violence from the victim. The fear is assessed subjectively. The jury must be satisfied that the defendant genuinely feared such violence, even if unreasonable. Very important. So it's subjective. Fear must be from the victim against the defendant or another identifiable person, not general fear. This accommodates domestic violence situation and protections of others, so such as the children of the family. Fear trigger is an example here. Jackie has enjoyed 5 years of violence from Steve, especially when he's drinking. One evening he returns drunk and approaches her. Jackie picks up a kitchen knife and stabs Steve. Analysis: provided Jackie lost self-control, she can rely on section 55.3 if she feared serious violence from Steve. The same applies if she feared violence against their child. No objective element exists. Question is whether Jackie herself was in fear, and I want to emphasize genuine fear. The anger trigger requirement. This is the second trigger. Section 55.4 requires things said or done that are of an extremely grave character. Circumstances must be of an extremely grave character, and there's no statutory definition of that. And there needs to be this issue of justifiable sense of being wronged. So must cause the defendant to have justifiable sense of being seriously wrong, and that's an objective test. The Law Commission gave examples of a parent finding a child being raped as meeting Section 55(4) criteria. So there's a judicial filtering role in this part. So whether a defendant's sense of being seriously wronged is justifiable is an objective question, determined initially by the judge. The judge decides whether a properly directed jury could reasonably conclude it was justifiable. Only then should the judge leave the question to the jury. The judge effectively acts as a filter, preventing inappropriate cases reaching the jury. An example of honour killing: Steve discovers his sister Anna has a boyfriend kept secret due to family anger. Enraged, Steve kills Anna, believing her relationship brings family shame. So in terms of this one, this analysis here is Steve personally feels dishonoured but cannot rely on Section 55(4). The jury would unlikely consider Anna's relationship extremely grave circumstances, and Steve's sense of being seriously wronged isn't objectively justifiable, and the result therefore would be Steve is guilty of murder. Look at sexual infidelity. This causes some confusion, partly because of what the Act says and partly because of what a case says. But the Act says this: Section 55(6)(c) deliberately excludes sexual infidelity as a qualifying trigger. Historically, the defence was commonly used by defendants reacting to a partner's adultery. The government stated the defence would apply only in extremely grave circumstances, eliminating routine relationship conflicts. Sexual infidelity alone cannot constitute grounds for justifiable sense of being seriously wrong. But then you also have the case of R versus Clinton, and that's the context consideration. The Court of Appeal in R versus Clinton, Park and Evans ruled sexual infidelity isn't subject to a blanket exclusion because it was seen as too harsh. Where it forms essential part of a context with other triggers, it may be considered. So sexual infidelity cannot be the sole trigger, but it can be a background to other qualifying triggers, those two triggers, when assessing their gravity and impact. So an example of this is where Steve and Jackie are married for 10 years with 4 children. Jackie wants a divorce and taunts Steve about her sexual infidelity, his suicidal thoughts, and the lack of care for the children. Steve beats Jackie to death. The result here is sexual infidelity provides a background, a context. Combined with taunts about suicide and children, circumstances may constitute extremely grave character, causing justifiable sense of seriously wrong. Murder may, in this case, be reduced to manslaughter. So just as a summary, sexual infidelity cannot stand alone. Sexual infidelity cannot be relied upon as a sole qualifying trigger. Context is relevant, can be considered alongside other qualifying triggers as background context. And there's an assessment factor here may be taken into account in the third element, examining reasonable person reaction. So let's look at the third element. So first of all, there has to be loss of control. Secondly, there has to be one of these two qualifying triggers, or both, the fear or anger. And then you've got this third element, similar reaction test. So section 51(c) requires that a person of a defendant's sex and age with normal degree of tolerance and self-restraint in the defendant's circumstances might have reacted similarly. This primary objective test maintains rule of law standards whilst providing compassionate outcome for those unable to meet the standards in specific circumstances. The killing isn't acceptable, but defendant receives a partial defence. So circumstances definition. So section 54(3) defines circumstances of defendant as all the defendant's circumstances except those whose only relevance bears on general capacity for tolerance or self-restraint. The normal person has the same history and characteristics as the defendant relevant to the qualifying triggers, but cannot rely on particular aggressive or short-tempered characteristics as an excuse for loss of control. So look at this issue of age and sex consideration. Age factor. Children generally have lower capacity for self-control than adults. Age provides some objective measure of expected tolerance and self-restraint levels. Judging younger people defendants against older adult standards would be said be unfair, but I'm not going into the criticisms of the law, just to say, look, some people refer to the issue of maturity as being better than the term age. Then the second consideration is sex. The law implies different sexes may have different self-control levels in some situations. Note the term sex, not gender. Most relevant for fear of serious violence trigger, recognizing it is said physical power differences and varied threat responses from different sexes. You may agree and disagree with what the law is, but that's what the law is. So going back now to these true and false questions, I want you to see whether you get these questions right. Pause it. Look at the true and false. Pause and check your answers with the next slide. This is the answers to the true and false. Look at the single best answer questions. You've got single best answer question 1, single best answer question 2. Pause it, see what your answer is, check the next slide. And here's the next slide with the answer. Feel free to pause it, read it in your own time, and then look at the final single best answer question, which is a little bit more facts to it. And this one is about sexual infidelity and the role it plays and does or doesn't play in loss of control. Pause it, see what your answer would be, and look at what the next slide says, which is the answer. Now, just by way of summary, there are 3 elements for loss of control: an actual loss of control, the 2 qualifying triggers, it can either be fear or violence or extremely grave circumstances, and there needs to be a similar reaction. A normal person might have reacted in a similar circumstances. All 3 elements must be satisfied to reduce murder to voluntary manslaughter, providing justice while maintaining legal standards. And then the final slide, look at this slide. So for the partial defence of loss of control to succeed, first of all, there needs to be actus reus, unlawful killing of a human being. Secondly, there needs to be mens rea, with intent to kill or cause grievous bodily harm. And where partial defence of loss of control kicks in is if the 3 elements exist. Defendant actions result from a loss of control. That's the first element. Secondly, there's a qualifying trigger. It can either be fear and or anger. And then the third element, a person of defendant's sex and age with a normal degree of tolerance might have reacted in the same or similar way. If they are proven, the charge of murder is reduced to manslaughter. I hope this criminal law class has been useful. Please re-watch the video. Please look at your resource books that you have, make notes, and look at single best answer questions if you have that type of assessment. And if you've got an essay style question, then read the book with a view of applying the facts to particular issues and those elements. I hope you found this criminal law class useful. Please watch all the criminal law classes on homicide. So I've done one on murder, I've done one on diminished responsibility, loss of control has been this one, and the next 2 are also important: gross negligent manslaughter and also unlawful act of manslaughter. So please watch those 2 videos too. So see you in the next class.